for today, the presentation, it's hard to put a lot of information in 1 hour. So while working with the counties that I do, I felt it's best to start with an overview of sexual harassment because while some have HR departments, many do not. So I would also encourage you to seek out other training if possible, especially have the training more in regards to what your policies say. So I know that there are some, for our entity, for IMWCA, we offer some webinars, web training with our online university. I believe ICAP has a employee sexual harassment training as well as a supervisor training. So basically what I'm trying to say is that this should not be the only training you're doing for your employees. So without anything more, we'll go ahead and start. I'm planning on going through the webinar and then taking questions at the end. So the outcomes of today is we're going to define sexual harassment. We're going to talk about the different types of sexual harassment, what the employer's responsibility are, what the employee's responsibilities are, and then if there's time, we could review steps to handle just general employee conflict, but there may not be time depending on questions. So the governing bodies or the governing laws that cover sexual harassment are the Equal Employment Opportunity Commission and the Federal and State Civil Rights Act. It is unlawful. So not only is it bad practice, it is unlawful to harass a person because of that person's sex. Sexual harassment, contrary to many beliefs, doesn't have to be sexual in nature. It could be, something that's more gender-based discrimination, a comment about women in general or men in general that's derogatory. So it's not necessarily a sexual comment. So it can be both the victim and the harasser can be of either sex. They can be the opposite sex. The victim and harasser can be of the same sex. There's just a lot of variety that can come into play. So when in doubt, obviously make sure you're investigating. So the two types of sexual harassment, the first is the quid pro quo, which means it's Latin for this for that, or something for something. This is the standard sexual harassment that you usually think about when you see movies or television. The victim is an employee, or it can be an applicant. The harasser is in a position of power, whether it's a supervisor, manager, owner, just that they have that position of power over that employee. The harasser's words or their conduct makes that employee's employment feel conditional. So it can be both implied and actual doing it. So the supervisor can make a comment that says, if you perform this sexual act, if you date me, I will give you this, or I will promote you, or I will provide you with a raise. So it can be a very exact statement, or it can also be implied. So I think a lot of places people get in trouble is the implied. A manager might be attracted to a subordinate and feel that they can make a comment like, would you want to go on a date? And if it's implied, that individual employee might not feel that they can say no, so they say yes because they feel that power over them. So it might be in that manager's best interest, and they don't think that they're actually sexually harassing somebody, but because that employee feels it's implied, it could be. So it's a very tight gray line to walk when supervisors are wanting to try to date or have a relationship with employees. So definitely, steer clear, try to have relationship agreements if you have employees that are dating. I know that there are a lot of small counties, small towns where there might be people in relationships and positions. If you have the family or marital or people that were in a relationship, you should look at different options for those employees, whether it's a relationship agreement or a dating agreement. Essentially what you're wanting in these situations where potentially a supervisor is dating a subordinate, some type of notice that these both employees are saying that they realize they're dating now. It could become a conflict in the future, and they're both understanding that there's not sexual harassment at this point. There's definitely, obviously, this would be a time where you would use legal help to guide you through this practice. But you know, in the world that we live in, where a lot of you are in small town Iowa, and there could be more nepotism than there would be in a bigger city. So the ideal is not to do it, but the reality is that sometimes it comes into play. But for it to be quid pro quo, again, there has to be a person in power. The victim has to feel that that person is making their job or portion of their employment or benefits a conditional that if something isn't done, they could lose out on wages, employment, etc. And that because of that comment or because of that conduct, the victim has been harmed. So these, you know, again, think of your traditional, think of the Hollywood, you don't get this role in this movie if you don't do this with me. That is what quid pro quo is. The other type of harassment is the hostile work environment. And, you know, we're talking about sexual harassment today, but it's not just sexual harassment that can cause a hostile work environment. It is also, you know, any type of protected class, any type of discrimination. So just kind of keep that in mind. We'll talk a little bit later about the protected classes in Iowa. But in the hostile work environment, the conduct that the victim feels, it's unwelcome. It has to, and for sexual harassment, it has to focus on the sexuality of another person or the person's gender. So again, it doesn't have to be sexual in nature, but it can be based on the person's gender. It can be a comment that all women are this or all men are this based on that person's gender. It has to be severe and pervasive, which makes it a little bit difficult because you can't just say, well, it happens frequently, so it has to be sexual harassment, or if it only happened once, it's not sexual harassment. So it's a balancing act between the two of these. If you have an employee that is sexually assaulted, obviously it's severe enough that one time would be enough to constitute sexual harassment. But if it's an offhanded comment that one employee makes to another employee and the witness just happens to witness it, it may not be severe enough. So these are all things for a court to decide, for the EEOC to decide, for the Civil Rights Commission to decide. But bottom line, if in doubt, it could be a problem. So just make sure you watch what you say and where you say it. And then for a hostile work environment, for the sexual harassment, it can be verbal, it can be physical, visual, written. So, you know, emails, texts, you see a lot of people getting in trouble with some of that, especially, you know, look at the politics, Washington, D.C., there's definitely texts going around that have gotten people in trouble for some sexual harassment. It could be as simple as a pin-up poster or a calendar with images of women. I've seen those out on my visits. It could be, you know, physical, just touching. Verbal would be any type of comment or joke or inappropriate questions, anything. And as we know, in today's day and age, times are changing. What may have been allowed to be okay in the past is not anymore. The silence is definitely breaking. So who can the harasser be? Well, the harasser obviously can be the victim's supervisor. It can be a supervisor in another area. Both of those, you know, would fall within the quid pro quo or the hostile work environment. A coworker can be the harasser. Usually in that situation, if they don't have control over the employees, you know, that don't have the ability to fire them or punish, you know, discipline them or make their job conditional, then it's probably not going to be quid pro quo, but it could be hostile work environment. And then the one I think people tend to forget about is a non-employee. A client, a customer, a vendor can be the person that's sexually harassing someone. And those are sometimes hard to deal with because you don't have direct control over those individuals. So, you know, what should be done? You have to remember, you have to focus on the impact of the behavior, not the intent, because people might say, I didn't know, you know, it wasn't my intention to make that employee feel that way. It wasn't my intention to sexual harass them. I was just asking them out on a date. I didn't know when they said no, it didn't mean no. I felt that, you know, they flirted with me or that they were really interested, so I asked a couple times. It wasn't my intention. Well, from the law, intention doesn't matter. What matters is how that person feels and what the impact of the behavior is. Again, it doesn't matter if a person feels, and you can have the best intention, but if that person feels harassed or feels that their job's in jeopardy because they didn't do what you wanted them to do, or they did it because they had to, it's probably going to fall within the realm of sexual harassment, and you can't go off intention. So intention is not a good defense, that is for sure. And I guess the thing you have to remember is not everyone reacts to the same behavior. So whether you tell a joke or show a picture, some people might think it's okay and laugh, and some people might not think it's so funny and feel harassed. And I would say, you know, growing up in small town Iowa, I'm also on a volunteer fire department. Things that I am okay with and comfortable being said, I would definitely know some counterparts of mine in the HR world would definitely not be okay with. So you never know what somebody's threshold is for what's acceptable or not. So that kind of leads into, you know, welcomed versus unwelcomed. You know, what about the employees that have a different tolerance or a higher tolerance, that are okay with that sexual banter or flirting or hearing and telling dirty jokes? What if you think you know that they'll be okay? Well, you know, I tell you to be cautious, because you don't know who's around when you're having that banter or you're telling those jokes. Well, the person that might be on the receiving end of the joke might think it's funny. The person around the corner or down the hall might not think it's funny and might not welcome that behavior. And it doesn't take a direct sexual harassment to the person I'm talking to or the person that's talking to me. Witnesses can also file claims of sexual harassment based off things they hear or see. They have the obligation to report something if they feel it's not appropriate. Obviously, also, people might pretend to welcome the behavior. They might not want to make waves. They might not want to be retaliated against if they say something, which actually in 2017 with the EEOC, the most frequently filed charge was retaliation. 48.8% of all the claims and charges filed with the EEOC were based on retaliation. And what that is when somebody complains about something, then they're retaliated. They might be demoted or fired or discharged, disciplined for filing a complaint. So 48% of all charges filed, almost 49% were based on retaliation. And then 30.4% were on sex. So people might not say something to protect themselves from any type of retaliation, even though it is obviously illegal. And then the other thing is, what might be appropriate to somebody today might not be appropriate in 2 weeks, or it might no longer become funny. Their situation might have changed. They might have personal things going on that at one time it was okay to say and now it's not. So just because you feel it's was okay to say something in the past, or that this person was okay with hearing the jokes you had to tell, doesn't mean that it is now. And again, you could say, my intention was never to be this way. I've told this person jokes before. I didn't know they wouldn't like it. Bottom line, you're responsible for your actions and your words. So why do people harass? Why do people do that? Well, there's a variety of reasons. Obviously, it's sometimes a dominance of power. It's wanting to dominate or power someone, maybe especially in the quid pro quo arena, where that boss wants something or wants to control somebody. It also is a way to organizationally or socially control someone. So while that individual or might not be a supervisor or a manager of the victim, but they're somebody that's a coworker and feels that they have the ability or the right to control someone. They feel dominance just by controlling someone in a sexual aspect because they don't have that dominance in work. It could be an attempt to seek peer approval, a bunch of employees trying to be funny and show off for their coworkers. And it can also be as a bullying tactic, trying to prevent somebody from getting an advancement that they didn't get, or not being happy with a coworker, wanting what they don't have, a way to intimidate them, maybe get them to quit. So there are a variety of reasons why people harass. So what are the effects of harassment? Why should you care? Why should you care other than the fact it's illegal? Well, it's been proven that harassment can cause increased absenteeism. Victims don't want to work in an environment where they don't feel safe, where they don't feel comfortable. You're going to see an increase in their absenteeism. They're going to become less productive. Obviously, one, if they're absent a lot, that's going to contribute to productivity, but also they're discontent, and if they're anxious while they're working and they're worried about being sexually harassed more, they're not going to be able to focus on what is their job. They're going to focus on when's the next bout of harassment going to come and in what form is it going to come in. It obviously could increase healthcare costs. Think about the emotional, social aspect of it, whether it's mental health or, lack of sleep, lack of eating that contributes to a poor health just from a physical standpoint. It obviously leads to a poor work environment, morale. People don't feel valued. They don't feel comfortable coming to work. They're scared. They're intimidated. It's not going to bode well for a good place to work. Obviously, people can quit because of it. It increases employee turnover. And it doesn't even have to be the victim. It could be the people that witness it, or if people in the department know that sexual harassment is allowed to continue, they might not want to continue working in a place that allows that behavior. Poor public view. I mean, everything in local government, for the most part, is open record. It could tarnish the reputation of the entity very easily. And then for all of that, there's the litigation costs are astronomical. You don't even have to go to trial to pay hundreds of thousands of dollars. I mean, the time put into a civil rights or EEOC claim is high as well. It's you have to fill out a questionnaire. It could be the last time I had to fill out a civil rights complaint, I think I sent back 45 pages with documentation and answering questions. So, and it's very time consuming, and you're just trying to give information to prevent this claim from going forward. That's just the basic civil rights EEOC process, let alone if somebody decides they want the right to sue and take it to trial. Think about the state Republican case for sexual harassment last year. It ended up being I think $1.75 million verdict. I mean, that's a lot of money when it can be prevented. So we talked in the beginning about the laws that cover, obviously, and I referenced the Civil Rights Act in the EEOC, the Title VII of the Civil Rights Act, and then the Iowa Civil Rights Act are the laws, the acts that govern harassment. And in Iowa, the Iowa law is more strict than the federal. So if you're currently just looking at the federal, make sure you look at the Iowa law as well. The covered entities, or the covered protections, are age, color, creed, gender, mental disability, national origin, physical disability, religion, retaliation, sex, pregnancy, sexual orientation, and genetic information. So all of those are protected classes. All of those can have a harassment, discrimination claim filed with the EEOC and civil rights. So just kind of wanted to go over those as a refresher to make sure people understand and are aware. So what is your responsibility as a county? What is your responsibility as an employer? You have a duty to prevent sexual harassment. And prevent isn't it's a proactive term. It's not a, hey, this happened, let's take care of it now. You have to prevent it. You want it to not happen at all. So what do you do in a situation where we touched upon when it's a customer or a vendor? Because you don't always have control when it's that situation. Other situations where you might not have control, again, we kind of touched on relationships in the workplace. You know, unless you absolutely forbid relationships and have a nepotism policy and pretty strict policies, it potentially could happen, but you have to be proactive on how you're going to deal with those, you know, going forward. Non-employees, customers, vendors, people that come in off the street, you still have an obligation to protect your employees from these people as well. Conduct outside of work, your workplace, if you have employees that are going to conferences or going to training outside of their work location, you're not there, you don't have the ability to monitor everything they do, but you still have an obligation to protect your employees when they're in these situations as well. And then same-sex. Sometimes same-sex harassment is more difficult to control because it's not as obvious. You know, when you look at this specifically from a county aspect, your hierarchy is a little bit different since it's not the traditional boss, supervisors, employees. There's elected officials and appointed officials and board of supervisors. So in order for sexual harassment to be prevented, there must be a buy-in from leadership. And that can be and should be leadership from the board of supervisors, leadership from the elected officials, leadership from the appointed officials. You need to have a agreed upon county-wide view that this is not okay and that you're going to do whatever it takes to prevent it. That would include having a detailed anti-harassment policy. I want to say I read somewhere that like 98% of the employers in the United States have an anti-harassment policy. So really it goes more than just having a policy, because most places do have it, and I would say most handbooks do have a sexual harassment policy. But obviously we see in the news it's still happening, people are still coming forward. So as part of your policy, you want to have a simple, uncomplicated complaint procedure that lists multiple avenues. You don't want it to be just the supervisor that they can complain to, because the supervisor might be the harasser. They might not feel comfortable with the supervisor even if they're not the harasser. So you really want to have multiple avenues for complaining. Sometimes entities have a hotline, a 1-800 hotline that's not tied to any employees, and it talks to a completely individual, person off-site. Sometimes that's a little bit more comforting to a victim, that they can talk to somebody that doesn't know them or live next door to them or will judge them for filing this complaint. You should have an alternative complaint procedure or when it's the supervisor as a harasser. Obviously, again, many times people aren't going to report if it's their supervisor just for the fear of retaliation. Set the expectation and culture. Culture is key when it comes to good workplaces. And in my role with IMWCA, we talk about safety culture and a lot of different things. And really what it comes down to, culture is how people view their place of work. So people want to come to a safe work environment where they feel valued. Anti-harassment, anti-sexual harassment has to be part of the culture. It can't just be a priority. It has to be that the expectation is you will not tolerate harassment of any kind. And then you need to educate. You need to educate your supervisors. You need to educate your employees on your sexual harassment policy, on the procedure for reporting. And again, I touched upon this in the beginning. This is just an overview. This is just a 101. You really should be training on your policy, on the expectation, how you want your people to report. It used to be train every year, and I know that I have members that haven't trained for a couple of years. I would say at the maximum, you're training every year. You should touch upon it all the time, whether it's just, remember we have this policy, remember this is where you see the policy, remember we have sexual harassment, this is the complaint procedure. Make sure your employees know about it. Every employee that starts employment should know about it. Even if it's part of the handbook, you should potentially consider having a separate sign-off just for the harassment policy or the sexual harassment policy, so you know specifically that all new employees have written and acknowledged they understand it. It's just very important, especially in this day and age, that you are educating your employees on your policies. And then you also, the next topic is make sure that they know their rights. It might seem counterintuitive or interesting that you would say, well, I need to let my employees know about the EEOC and civil rights. They're gonna complain then. Well, if you're doing things right and you're following the law, they're not going to complain. But they do have a right to file a complaint with the EEOC and the civil rights. So, it is in your due diligence to let employees know that they have that option. And that should be part of their policy, that your policy that per these acts that you don't allow discrimination and harassment, and if they feel that they need to complain, these are the avenues of complaining, and that can be one of them. And then very big, as we know, with the 48.8% of the EEOC claims being retaliation, you must prohibit and prevent retaliation, because if that happens, if that occurs, not only are you going to have a sexual harassment claim, you're going to have a retaliation claim, and your troubles are just going to get that much more complicated. So in the June 2016 EEOC report, 75% of harassment victims were also victims of retaliation. So if you think about it, of that 40, well, this was a 2017 number, but for sheer basic numbers, of 48.8% retaliation claims filed, roughly 75% of those were also victims, were harassment victims that filed retaliation. So usually a retaliation claim comes upon some other type of complaint. So just, I guess, be very, very cognitive. And again, you might not intend to retaliate, but it depends how that person feels if they feel that they're retaliated against. So even simple frustrations that somebody filed a complaint and how much work they have to do to fill out the form, if, then it leads to this employee suffering in their employment, could be perceived as retaliation. So I guess I cautious you to be very, very, very cognitive of what you're doing and what you're saying, especially after a claim has been filed. And don't fire that employee for filing a complaint. It seems very basic, but I read all the time. I get EEOC updates that talks about the claims that are being settled and the dollars that are being spent to settle it. And oftentimes it's they fired this employee for filing a complaint. They fired this employee. They terminated this employee. So it happens. People feel that they can just get rid of the problem by terminating the employee, and it doesn't work that way. So be very cautious. Talk to your attorney. Again, you have a county attorney, if you're an ICAT member, you have 3 hours free legal advice with an employment attorney. I know many of you have collective bargaining or unions where you use attorneys to negotiate your contracts. Just make sure you seek out legal advice before you make a decision you're going to regret. So employer responsibility continues on. Not only do you have to have the policy and prevent retaliation, you also need to make sure you address and investigate every complaint. Even if you feel that it's not sexual harassment, you might have an opinion, you might know more information about it than the victim thinks you do, and you might just want to say, well, I know it's not harassment, but every complaint needs to be investigated thoroughly, because you don't know, and a lot of times there are also court cases that go to trial because the employer failed to investigate. They just assumed it didn't happen. So make sure, no matter how small you feel it is or how insignificant, somebody might complain and you laugh thinking, I can't believe somebody would say that's sexual harassment. It's not you, it's how they feel, and you still have to do your due regard to investigate. If during your investigation some corrective action is warranted, you make sure that it's done immediate. Make sure you're not waiting for a couple weeks before you assign that corrective action or you discipline, because again, you want it to be corrected immediately. And then through that whole process of the investigation and the corrective action, if warranted, you're documenting everything, because it could be your best defense, or your worst if you don't have any documentation. So when you're performing this investigation, there might be some questions you're going to ask. There's definitely questions to ask, and there's questions not to ask. You want to touch on like the root cause of what happened. Where did the behavior occur? Who was involved? Were there witnesses? You're going to want to talk to the victim. You're going to want to talk to the witnesses. Find out if this employee talked to anybody else. Is what they told that person the same? Was there more information given to somebody else? Has it happened before? That's going to help you with has it happened frequently? Is it severe? Has it been going on? How long has it been going on? Is it a one-time thing? Has it been going on for a couple years? Try to find out as much as possible. And then, not that this matters, because it doesn't, but did that employee, that victim that's complaining, did they ever tell the employee, the other person, that behavior was unwelcomed? Again, it doesn't always matter, but it's a good information for you to know doing your investigation. Questions you shouldn't ask, or you should ask in a different way, would be why questions. You don't want that victim to feel like you're attacking them. You don't want to say, why didn't you do something about this before? Why didn't you tell us about this before? Why are you just telling us about this now? You want to make them feel comfortable so that they are more as forthcoming with information as possible. You don't want to have leading questions. You don't want to say, would you want to continue working here? What do you think you did to have this person say this? You don't want to lead that employee to a certain answer. You want them to come up with it on their own. And then obviously, don't ask them multiple choice questions like, did he touch you here? Did he touch you here? Did he touch your shoulder, your face? You want that employee to give you the information. So where did he touch you? What did he say? Instead of, did he say this or did he say this? No, what did he say? So these are the things, like, you just don't want to lead this investigation. You want this to be the victim or the employee telling you. So the employees also have a responsibility. So if you're listening and you're not a supervisor, you're an employee, or even as a supervisor, if it's not your employee, you do have a responsibility. You don't engage, don't condone sexual harassment, don't be the one that's telling the joke. Don't be the one making the comment. Don't be the one putting up the new calendar this year. You know, the world is changing. Things aren't going to go back to the way they were. So, you know, don't encourage your peers or your fellow employees to not report it, but don't encourage them to banter with somebody. And you know, for sure, don't encourage an employee not to report sexual harassment. So if you have a coworker that comes to you and says, "Hey, I think I was harassed," or, you know, "My supervisor said this and I don't think it's right. You know, what do you think about that?" Don't say, "Oh, don't think it was anything. I think you should just forget it and go on." I mean, definitely support your employees. Remind them of the policy. Remind them of the procedure, but don't condone, because like I said, the world is changing for sure, and things that may have gotten by for years and years aren't going to be getting by with going forward. And then if you are a witness, or, you know, it might not be you that is being harassed, but if you see sexual harassment, or you see something that makes you feel uncomfortable, or you see that maybe an employee is being talked to and they might be fearful, but that you can tell they feel uncomfortable, make sure you report that. It's really not just up to the harasser and the victim anymore. We have a duty as employees to maintain this good culture, and part of that is by being strong enough to stand up for others. So, you know, again, it's just kind of a reminder that times are changing. You know, just look at the last year, how many people have come forward with sexual harassment claims, whether they're, you know, whether it's a movement, whether it's whatever it is, things are changing. And again, I don't think it's going to change for the way it used to be. So you need to make sure you protect yourself, that you have your policies in place, that you have your procedures in place, that you're doing your training, that you're, you know, look at your policies. If you haven't looked at your sexual harassment policy in a couple of years, you probably should dust it off and look at it again. See if it's the way you want it to be. See if your complaint procedure is as clear as it should be. See if there's multiple ways for somebody to complain. Make sure that there's an avenue for somebody to complain if is their supervisor. You know, now is the time, because you want to be able to, again, stay proactive. You don't want to be caught having to try to make all these changes after a complaint's been filed. So that in itself is Sexual Harassment 101. I guess at this point I would answer questions if anybody has them.
I don't have any right now. I'll just give a quick reminder as well. We do always record the webinars, and we'll make them available on our website. So if you go to the Meeting and Events tab, all the way at the bottom is Webinars. If you click on that, all of our past webinar recordings are on there, and this one will be up in just a day or two as well.
I think things to remember is you can get into a lot of more detailed training. You know, again, this was just an overview, kind of a starter place for people that may not have HR or not even know where to start with the sexual harassment training. But there are places to go. There are videos. There are people that will come do face-to-face training. But I would recommend as an employer that you should, again, at the maximum once a year, do a training for your employees in general, and then do another training for your supervisors, because they have a little bit of a different threshold for their responsibilities when it comes to sexual harassment. For the employee portion, you want to train your employees on, again, your policy, the procedure for complaining, you know, what's not, what could be taken as harassment, what's potentially not, what things they should look for, how to deal with it if they're witnesses. So, you know, that would be a good training for all the employees, even for you as a supervisor to sit in on. But the other training that you would look at doing then was having a portion of it be for supervisors. So how to deal with it if an employee would file a complaint, or how to deal with it when the employee comes to you and says, hey, I think I've been sexually harassed. So then you're not standing there going, well, what do I do now? Have somebody come in, watch a web video. Again, I know ICAP has a video for supervisors and employees that is really good about recognizing sexual harassment, how to work with your employees to get through the interview process, the steps to take. And as always, rely on your legal team, because even through the civil rights complaint and the EEOC complaint process, it is timely. And it is good to have an attorney go over your answers to ensure that what you're saying is okay. And a lot of times in those if somebody files a complaint, EEOC is going to ask for a copy of your policy. It's going to ask to see if your employees have been trained. They're going to ask, what has happened and what have you done to prevent this in the future. So those are just kind of some reminders of what you should do in your training going forward.
We had someone ask if it is best to have an outside person do the investigation of a claim.
I would say if you have an HR department that potentially they could do it, but I don't think you'll ever go wrong having an outside person do it. I know that sometimes attorneys, like if you have your own labor attorney, they might bring in somebody on a third party or like independent, just from the, I guess, nature of attorney-client, that bringing in somebody independent would help you in that process. There are attorneys that would do that. There are actually HR consultants that will do that. You're not going to go wrong doing that, and really it's probably not a bad idea. If you have an HR department, obviously work with them first to see if that's the way they handle things. But if you don't have an HR department, then yeah, I would for sure bring in an independent person to help you through the process, especially somebody that's done that type of investigating before and knows the law and understands the civil rights, the EEOC aspect.
We had another question by Julie Chapman. Is there any length of time in which a complaint can be turned in for review?
With the county specific, or I believe that, I'm going to go back to I want to say that, actually go up, sorry, hold on. I think an employee has 300 days from the last incident of harassment to file a claim with the EEOC. Don't quote me 100% on that, but I'm pretty sure it's 300 days to file a complaint with the EEOC. Yeah, 300 days from the last discriminatory or unfair practice to file a claim. So as far as the statute for you internally, that I'm not sure of, but they have, the 300 days, so it could happen today, and they have almost a full year to go ahead and file with the Civil Rights EEOC. So there's some time there. That's why it's so important to be proactive and stay ahead of this and prevent it from happening.
Perfect. Well, it doesn't look like we have any more questions at this time. Lisa, do you have anything else to add?
No, I just, I guess be aware. I said no, but just be aware. It doesn't take anything but looking at the paper or watching the news to see how much things have changed in just a year's time, and the threshold of people, I would say, putting up with things. So just because you behave the same way or allowed the same behavior in your department for, say, 30 years or 10 years, be cautious and be aware that it's probably not going to be okay anymore. So you might have to look in the mirror or look at your department from a different lens and say, is what we're doing okay? Well, it may have been okay in the past, is it still okay now? And if you can't answer that it's okay, then maybe you should be changing your practices and encouraging your employees to change their behavior as well.
Perfect. Well, if we don't have any more questions, we'll go ahead and end the webinar. Thank you for tuning in, and if you have any questions after the fact, you can go ahead and contact ISAC or Lisa directly, and we'll be happy to get that answered for you.
All right, there's my contact information.
Perfect.
At the bottom. So thank you
again. Have a great day.